Why is the theft of rental services not considered a crime in Ontario? Theft of rental services, or rental fraud, involves tenants not paying rent or continuing to occupy the rental property without authorization. While it might seem like theft, it is generally treated as a civil matter rather than a criminal matter in Ontario and many other jurisdictions. I know, it just seems wrong. So let's look at some of the reasons why. Legislation and processes. The non-payment of rent and disputes over rental agreements falls under civil law, which deals with disputes between individuals or organizations. Criminal law, on the other hand, deals with actions that are offenses against the state or society at large. Non-payment of rent is viewed as a breach of contract rather than a criminal act. In Ontario, the Residential Tenancies Act governs landlord-tenant relationships and provides a framework for resolving disputes, including those related to the non-payment of rent. The RTA outlines the rights and responsibilities of both landlords and tenants and provides legal recourse through the Landlord and Tenant Board. Part of this recourse includes the eviction process. The RTA specifies procedures for dealing with non-payment of rent, including issuing notices to tenants and applying for eviction through the Landlord-Tenant Board. In theory, this process is designed to ensure fair treatment and due process for both parties. Let's look at the focus on remedies. The primary goal in cases of non-payment of rent is to obtain monetary compensation for the landlord. This is achieved through civil remedies, such as obtaining an order for payment or eviction from the Landlord-Tenant Board. The Landlord-Tenant Board can issue an eviction order, allowing the landlord to regain possession of the property. This process ensures that the landlords can remove non-paying tenants legally. The burden of proof between a civil standard and a criminal standard is very different. In civil cases, the burden of proof is based on the balance of probabilities, meaning it is more likely than not that the breach occurred. This is a lower standard than the beyond a reasonable doubt required in criminal cases. Proving criminal intent, the act itself, beyond a reasonable doubt in cases of rental fraud would be challenging and resource intensive. That's not to say it can't be done. In fact, a landlord can initiate a private prosecution. Let's look at law enforcement priorities. Law enforcement agencies prioritize resources for crimes that pose a significant threat to public safety. Rental disputes, while serious for the landlords, are not typically considered a high priority event. They are much lower priority compared to violent crimes or significant financial fraud. Handling rental disputes through civil courts and specialized boards like the Landlord-Tenant Board is more efficient and appropriate given the nature of these issues. Then there's tenant protection. The legal framework aims to balance the interests of landlords and tenants. Treating non-payment of rent as a civil matter protects tenants from potential criminal prosecution for financial difficulties and ensures they have access to a fair dispute resolution process. While the non-payment of rent can have significant financial implications for landlords, it is treated as a civil matter in Ontario to ensure that disputes are resolved fairly and efficiently within the framework of the landlord-tenant legislation. The focus on civil remedies, due process, and the appropriate allocation of legal resources underpins this approach. Landlords facing issues with non-paying tenants should seek recourse through the procedures outlined in the RTA and the Landlord-Tenant Board. However, should a landlord feel that the tenant engaged in deceit and fraud intentionally, the landlord may still have an avenue through private prosecution in Ontario.